Your Honor, I've been before the court this morning in the matter of the state of Ohio versus Nicole Henderson, actually two cases, Your Honor, of the lesser included offense of count one being F5 escape and count two F5 vandalism, pleading guilty and found guilty of count two F3 robbery, count three F5 possession of cocaine, and count six F3 tampering with records. Parties are ready to go forward, Your Honor.
I'd like to first focus, Your Honor, on that psychological report from Lake County, or from Lake Geauga, excuse me. Indicates, Your Honor, that my client has been previously treated and diagnosed with anxiety, depression, post-traumatic stress disorder, borderline personality disorder, bipolar disorder, heavy drug addiction, that she has had an extremely difficult past. She suffered sexual abuse as a child. She later was a victim in a human trafficking matter, and certainly her ongoing drug use.
Welcome to Court and Case, where the law meets the facts. Get ready to dive deep.
Drug use led to the instant offense. I would indicate, Your Honor, that the report indicates a very thorough and treatment plan should she be given an opportunity on community control, and we would ask that the court would consider an opportunity on community control. Your Honor, certainly my client has accepted responsibility for her actions. She was treating and on methadone, Your Honor. She relapsed. She was significantly drug addicted. She was purchasing drugs from less than wholesome individuals and owed them a good deal of money. She was in a situation where she either needed to obtain the funds to pay them or believed that she was going to be forced back into prostitution as she couldn't pay for the drugs that she had previously purchased and not paid for. That led to this incident, Your Honor, where she was initially in a store, had a cart full of items, was approached from somebody who worked at the store, turned around almost impulsively and threw a deodorant at them, not striking that individual. Certainly under the law, that is basing grounds for a robbery, which she accepts responsibility for, Your Honor. I would submit, until I attended law school and familiarized with myself with the laws in Ohio, that is certainly not what I would think of as a robbery offense, even though certainly under the law it is. But I would submit to the court that that is probably one of the lower forms of the offense when looked at it as a whole. This wasn't something with a firearm or a knife or a serious...
Yeah, but this is an F3 robbery. It's not an F1 robbery and F2 robbery. It's an F3 robbery.
It is, Your Honor.
So you can't compare an F3 robbery to an F1 robbery and F2 robbery.
Certainly, Your Honor. But I would submit that she threw a stick of deodorant, Your Honor. After that, she still needed to obtain money, went to another location and was engaged in the same behavior. When approached by authorities, she gave her sister's information knowing that she had a warrant out for her arrest, Your Honor. She's extremely apologetic. She knows she shouldn't have done it. She knows she's going to face consequences from this court, and she's prepared to face those consequences. I don't think she's really ever taken treatment seriously. She has had her third child. She understands that she needs to be there for her children, regardless of whether she serves a prison sentence or gets out. She needs to treat, and she needs to get help, and she's of no use to her family unless and until she does get that necessary help. And would just request, Your Honor, that the court, however it deems fit, would give her an opportunity to get that.
And say whatever it is you'd like me to know or consider. Is there anything you want to say at this time?
There's so many things I want to say, but first, I know I'm here to take accountability for my actions, and they got me here today, and the choices I made leading up to this. The true meaning of taking accountability is confessing what I did wrong and not giving excuses for that afterwards. I was wrong when I left the hospital and I cut the ankle monitor off. And the Lake County Sheriff's Department was only trying to help me and my own unborn baby. I was wrong for the way that it is going to affect the next person who get put in this situation, and I truly apologize for that. I was wrong when I left my mother's house after being sober for a couple months and having my baby sober and relapsing instead of continuing to try to get into rehab and continuing to try to find a way there. Because actively trying to get in rehab. I showed up at Hitchcock House with inside the gate and they denied me. I sat there and tried to switch my insurance over and they told me there was a 14-day waiting period. I also had a bed ready in Ashtabula and my mom's car was broke down. The lady who was taking me to the methadone clinic 3 times a week all the way out. Supposed to take me to rehab 2 separate times and did not answer the phone that day. And it's not nobody's responsibility but my own.
Well, you said you're not making excuses, but that's what I'm hearing.
Huh?
You said you're not making excuses, but that's what I'm hearing.
Okay, you're absolutely right. I was wrong for using drugs that I did not have the money for. I was wrong for stealing groceries, and I apologize. Okay. This letter was just me admitting to every single charge and apologizing for it. And yes, I'm adding things into it even though I don't mean to. And I apologize for everything that I did. I apologize for not doing what I'm supposed to be doing. I'm not asking to get rewarded because of anything. I don't deserve it. I just don't know what to do at this point in time. I really don't. I don't know what. I don't. I've been doing this for so long. I just don't know what to do, and I sincerely apologize. I need help. I don't know how to live in the real world like every single one of you guys. I've been doing this for so long, and yes, I've never went and took myself to treatment before. And I don't know why I haven't. Other than what I've done since I've been out of prison last time, I need help, and I need somebody to help me, and that's so crazy to say because I'm an adult. I just need help. I really do. And I'm really not trying to make excuses. I'm not trying to explain anything. I'm not trying to do none of that. I'm just here to ask for help and to apologize for everything, the community, the stores, my mother. I apologize to my mother, my kids. I apologize to my sister for using her name. The probation will be on me about doing this if I listen to them, and if I really want this, I will put in the work every single day to do it, and that for the rest of my life. But even after probation, I don't care if I get 5 years on probation with NeoCap and everything. I don't just need treatment. I need to learn how to think right, to make decisions right. I need help with my trauma that I've been in. I need help with my addiction. It's all leading to one from another. I want to just be a normal person. What I've done wrong to them, including my family, my new baby, my older 2 sons. Maybe even one day help somebody like me. Because there's so many of us females out there that just nobody understands what we go through. And I don't know. I apologize. I really do. And I just need help, and I'm just asking for it. And I will show the court, I will show you, I will show my son, I will show myself, I will show my God that I deserve this.
Well, I mean, is there anything else you'd like to say? You don't have to say anything more, but I just want to make sure you said everything you want to.
No.
All right, thank you.
Yeah, the defendant has said repeatedly what she believes she needs is help, help, help. From the state of Ohio's perspective, what she needs to do is no longer commit crime. She has gotten help in the past from this court, from Judge Shirley Strickland Staff School downtown. She's been in our jail treatment program here in Lake County twice, once in 2016, once in 2022. She went to NeoCap. Now, that was 10 years ago, but it's the most intense treatment that we have, and it's supposed to stay with you. And instead of it staying with her, she just reoffended and kept reoffending. She had medically assisted treatment. She was ordered to an inpatient program. She left after 4 days. Representing the state of Ohio, I have to hear what the defendant says, and I have to question either she doesn't have any insight or she just can't do it. I don't know. But we can't have any more people getting hurt because she is going to use drugs and has mental health problems. Certainly it appears, has had a very difficult and hard life, and I'm sorry for that. but she keeps hurting people. She hurts her sister by using her name and signing her name on booking records when she gets arrested. And if we didn't have observant police officers who did their job very thoroughly, her sister would have yet another official record in her name of a crime that she did not commit. That's serious. That's serious. We're talking about felony crimes here. You know, this wasn't simply throwing a stick of deodorant at the employee at Giant Eagle who's just there doing his job. There was a tugging match with a shopping cart full of $1,600 worth of groceries and merchandise that the defendant was trying to leave the store with. So this isn't a matter that she took a candy bar and is walking out, or some makeup or something and is walking out. I mean, this is like organized criminal activity. She's doing it with somebody else. And it's premeditated. This wasn't a thought she had in the moment. She sought out to do it. And when she wasn't successful, she immediately went somewhere else. When they arrested her or when they detained her in Walmart, she had a whole shopping cart already full. It wasn't even that much longer. Okay, so this is sustained conduct that is criminal, where people keep getting hurt. Certainly, the state is sensitive to her upbringing and her problems, and God help me, I hope she gets it together, because we don't want her hurting anybody else. So the state believes prison is appropriate, is called for under the purposes and principles of sentencing. The state does believe that no more than 4.5 years total with both of the cases would be appropriate here, given the circumstances. She did take responsibility. I acknowledge that. Also, by agreement, would ask the court to order the defendant's voluntary forfeiture of the glass smoking device that had the cocaine on it in this case, and to order $75 restitution to On Track Solutions.
I received a victim impact statement from the defendant's sister regarding the tampering with records count. I've read and considered that. In 26 CR 439, that's the robbery charge of the cocaine, the tampering with records. Tampering with records was more serious. The defendant's relationship with the victim, and that her sister facilitated that offense. And it has caused her extreme emotional stress, quite frankly. I got a letter from her. You've been doing this for years to her. And not only does it affect her quote criminal history that she doesn't have, but it also medical. You go to the hospital and you tell them you're her. So now her medical records are tampered with and wrong. And she goes there and they look at medical records and it's got her coming in with your medical conditions that she's got to deal with. She's been going through this for years and you just keep doing this to her. And it's not as simple as just using her name. She's the one that's got to deal with the fallout from all that. Getting arrested, getting stopped by a police officer, her simple speeding ticket, and having a warrant out for her because you're using her name. Looking at her criminal record and it's your criminal record. Again, going to the doctors and having her medical records show all your issues. Why does she have to deal with that? But you just keep doing it over and over and over. The impact it had on her, it makes it more serious than the normal tampering with records case that we deal with, because normally it doesn't have that effect on individuals like that. Nothing makes any of these offenses less serious. As for recidivism factors, almost all of these are present. The defendant has an extensive criminal history going back 20 years. So you're only 36 years old, if I'm remembering correctly. Let's make sure of that for the record here. 36 years old, and your record goes back to 2007 as a juvenile. Then it's continued on as an adult. You've served multiple prison sentences, 3, I think, at least, by me, that I've had to impose. And that's after I initially give you an opportunity of probation. You have failed to comply with previously imposed sanctions ordered by courts. I've been dealing with you for 10 years now. You've been given chance. You sent me a letter. You read a letter. This is your case from 2016. This is your case from 2019. 2022 is on here. Got all the same letters from you. I read all the old letters. You say the same thing in the letter that you wrote me just last week. Nothing changes. You say everything that you think I want to hear, and then you don't do it. You need to be there for your kids. Started off as one kid, I think, now up to 3. But you need to be there for them. You're tired of living this way. You're going to hang around different people, new people. You've been telling me this stuff for 10 years. Literally the same stuff. You know, initially I hear it and I say, all right, maybe she's being sincere and genuine here. But now this is the 4th case you've had with me telling me the same stuff. And how am I supposed to believe that's sincere and genuine? Because you tell me the same thing every time. And you go out and do the same thing. When you were in jail, you couldn't even follow the rules. You're repeatedly violating rules in jail. Now, maybe they're not real serious rules, but they're rules, first of all. And secondly, you're doing them over and over, the same thing. You're going to do what you want to do. It's as simple as that. Your score, your ORIS score, is one of the highest I've ever seen. It's a 41. I think the highest, I'm not sure, it could be 43. You say what you think we want to hear. Maybe you believe that in the moment as you're sitting here, but as soon as you're out on your own, you're going to do what Nicole wants to do. You committed this robbery charge when you had warrants out for you for the escape charge. Nothing indicates recidivism is less likely. I mean, with the history here, recidivism is almost guaranteed. Under 2913B1, court finds defendant previously served a prison term. Prison is consistent with the purposes and principles of sentencing. And again, there's just no way this court can make the finding that be required in order to put you on probation that you're amenable to community control sanctions. On count 2, charge of robbery, defendant served a term in prison of 18 months. On count 3, possession of cocaine, defendant served a term in prison of 9 months. On count 6, defendant served tampering with records, defendant served a term in prison of 18 months. Court's going to order that the 18-month prison terms in counts 2 and 6 be served consecutive to each other. Count 3 will be concurrent with those charges for a prison term of 36 months in this case. On amended count 1, charge of escape, felony 5th degree, sentence the court defendant serve a term in prison of 6 months. The vandalism charge in count 2 is a term in prison of 6 months. By statute, those have to be consecutive to each other for a prison term of 12 months. And by statute, that prison term must be consecutive to the prison term in 26 CR 439, and I'm ordering that be consecutive. Order restitution to on-track solution, the amount of $75. In both cases, defendants ordered to pay all costs. Advise you that upon your release from prison, you will be placed on post-release control, mandatory in this particular case for at least 1 year, could be up to 3 years. I order that counts 2 and 6 be run consecutive to each other, and I find that consecutive service for those counts is necessary to protect the public from future crime and to punish the offender, that they're not disproportionate to the seriousness of her conduct and the danger she poses to the public. All right, thank you.
All rise.
She begs the judge for help, but he has heard the same promise for years. Nicole Henderson stands before the court, facing felony consequences for robbery, cocaine possession, tampering with records, escape, and vandalism. Her defense asks for community control, emphasizing addiction, trauma, relapse, and her need for treatment. Then Henderson speaks for herself. She accepts responsibility, apologizes to her family and the community, and repeatedly tells the court that she desperately needs help. But the prosecution points to her repeated offending and previous treatment opportunities. The judge then reveals why this case is different. Her criminal history stretches back to 2007. She has served multiple prison sentences, and she has repeatedly violated court and jail rules. The judge tells her that he has heard essentially the same promises from her for years, and the behavior keeps repeating. Community control is rejected. The court imposes 36 months in prison in the main case, with additional consecutive prison time. This time, the judge makes it clear: another promise isn't enough.